Hereby, I open this academic ceremony in which Clara Ducimetière will defend the academic thesis entitled Change of Paradigm, Intellectual Property in EU Investment Agreements. Dear candidates, may I invite you to present a summary of your study and the conclusions of your thesis.
Highly esteemed Prorector, highly esteemed members of the Corona, dear family, dear colleagues, dear friends. Thank you for being here today and making this defense possible. In the next 15 minutes, I will provide you with a summary and with the main conclusions of my work. My thesis is entitled Change of Paradigm, Intellectual Property in EU Investment Agreements. When I started this research in September 2017, it was only 6 months after the award in the Eli Lilly versus Canada case and just over a year after the cases opposing Philip Morris against Australia and Uruguay. These cases were really a turning point from theory to practice, where you could see the consequences of including IP in investment agreements, including the access to investment arbitration. These cases really constituted a shift, a change of paradigm for IP disputes. To set the scene very briefly and explain some of the concepts I've used in my research and that I will use in my presentation today, international investment agreements are agreements between two or more states. These contain rights and protections for investors. And it is based on these IIAs, as we call them, that investors can seek compensation, financial compensation from states for measures or actions they've taken. The aim of these IIAs is basically to promote private investment between the states. And so any dispute between the investor and the state is solved by what we call an investment tribunal, sometimes referred to as ISDS. This is an ad hoc tribunal made of 3 arbitrators selected by the parties. When I started this research, the first questions that came to my mind were, why are these cases a turning point? How can investors even bring IP disputes in investor-state arbitration? What are these IIAs saying? What are the standards of protection? And in sum, why is this problematic? Why do we have a problem? Then while doing the research, I realized, okay, a number of these more general questions have already been answered by the doctrine, and so I decided to narrow the scope of my research to focus on EU agreements and the specific issues that this creates in the EU. This is really where I identified a knowledge gap. And so in this research, I used 3 agreements as use cases: the CETA, the EU-Singapore, and the the EU-Singapore, the EU-Vietnam agreement. That allowed me to refine a bit my research question, which is, can a balanced investment protection system, including its dispute settlement system, be conceptualized in EU investment agreements for the protection of IP assets? To answer this question, I applied a mixed methodology. In the first part, that looks more at the theoretical framework around IP and investment protection in the EU, I used methodologies based on legal theory, philosophy of law, doctrinal research, and historical analysis. I also relied on policy analysis and comparative law. In the second part, that looks more at the adjudication framework. There I relied on empirical analysis, keyword searches, and arbitral awards and treaties, more generally on doctrinal research, legal analysis of case law, also relied on policy analysis. Finally, I used different types of sources, from primary to secondary sources. I'd like to say one word on what is outside of the scope of this research. So, while the broader international legal order and the rules on treaty interpretation served as the framework to study the relationship between IP and investment law as protected under EU agreements, a more thorough analysis of conflict of norms and treaty interpretation rules is outside of the scope of this research. Also, COVID-19 discussions are excluded, so I've not used the impact of COVID-19 related measures as a case study in this research, However, it can be very interesting for future research and especially to check whether the findings of my research can apply to these cases or not. Some limitations. So as I said, I used 3 EU investment agreements as case study. This means any of my conclusions are based on the legal assessment of the wording of these specific treaties. They cannot always be applied to any other investment agreement. We really have to look at the specific language of those texts. For instance, while I make some reference to the Energy Charter Treaty, the specific agreement was excluded from the scope, was not part of one of my case studies. Finally, there is a limit to the empirical analysis that I've carried out. This is because ISDS, as I will say later, is confidential often, and so I relied on publicly available data there. And there's also a time limit here to my research, so carried out until April 2022. Okay, let me turn to some of my main conclusions, which I will divide between the 2 parts. So in the first part, as I mentioned before, I really looked at the theoretical framework for IP and investment protections. So there, I can highlight 3 main conclusions. First, the investment function of IP rights is something that is intuitive for investors and businesses, and is also something that is increasingly recognized by the Court of Justice. However, the IP system in the EU really has its specificities with exceptions and limitations to secure the social function of IP rights, and this is really what is at risk with investment protection for IP. Second, IP is indeed, and that is one of the findings, listed under most IIAs. However, to benefit from investment protection standards is another story. And based on the case studies I carried out, I found that the threshold to find a violation of an investment agreement in relation to IP is rather high. And the mere inclusion of IP in the agreement is not enough to benefit from protection of those treaties. This is particularly true for what we call new generation agreements that have explicit safeguards for the public interest and for the right to regulate. It is not always true for what we call old generation agreements. So here I see an important role to be played by investment tribunals when interpreting those agreements. Finally, one word on competency and compatibility, because this research I really focused on the EU. So first of all, there was a big shift after the Lisbon Treaty in 2009. There, foreign direct investment became the exclusive competence of the EU. However, the court later decided that dispute settlement falls within shared competence. That sounds very theoretical, but in practice, it's had major impact, in particular when negotiating and then adopting those agreements. You need unanimity in the Council, and national parliaments must ratify the agreement, which means it can take years before an agreement actually comes into force. Second, with regards to what we call intra-EU BIT, these are agreements between 2 member states of the European Union. These were found to be incompatible with EU law, in particular the dispute settlement chapters of these BIT. 5 member states have committed to terminate all of those agreements. What I found in my research is that in practice there are still arbitral awards being issued even after the judgment of the court, ACMEA judgment in 2018. So, regarding extra-EU BIT, so these are agreements between one member state and another state, not an EU member state. These will progressively be replaced by EU agreements. That will take some time, but that is a bit the trend, not where we're going. The conclusion of this is that I see a very big role to be played by the EU to ensure that appropriate language is included in those treaties. Regarding now more the practice, adjudication, and the procedural aspects of investor-state dispute settlement. I asked myself, why do we even have investor-state dispute settlement, right? So I found that there is still, one of the reasons why states still included in their agreements, there is still a lack of confidence in certain domestic court systems, and there are also limits to other dispute settlement mechanisms that can explain why ISDS is still including in investment agreements. There's also an issue of enforcement. If you take away ISDS, you have enforcement issues. I then asked myself, how big of an issue is it really? Is it only a theoretical issue for academia, or is it really a problem in practice? Well, I found, and let me just say that this is really just the tip of the iceberg. I found that by the end of 2013, we had 568 known cases. By the end of 2022, it had more than doubled. So there is really an exponential trend here. Carrying out my keyword search, I found, however, only 14 IP cases. These are cases that somehow refer to intellectual property. And so out of these 14 cases, I took 4 of them, 4 iconic cases, the ones I mentioned at the very beginning in my timeline. And so I asked myself, what are the implications of these cases for the IP system? My conclusion is that these 4 cases did not really enter into in-depth discussion on the interpretation of IP law standards. While this could be seen as IP cases, they were, in my view, much rather denial of justice cases with limited discussion over the interpretation of IP standards. Still, there were some discussion over the right to use a trademark, for instance, in the Philip Morris versus Uruguay cases, but not much more. So in conclusions, this discussion with much more questions over the right to regulate to protect public health, and over the conduct of domestic courts. The conclusion there could also apply to non-IP cases. What is, however, in these cases extremely relevant for the IP system is the potential chilling effect of those cases. Specific to the IP system, for instance, chilling effect when a country wants to issue compulsory license. And there are real cases. There is a case in Colombia, for instance. Finally, in this research, I confirmed a number of the deficiencies and procedural deficiencies of classical investor-state dispute settlement. And maybe you've heard of some of those before. There are problems of independence, of consistency between the awards, of transparency. This is why before I mentioned the tip of the iceberg, so many cases that we don't know about. Problems of high costs, and most importantly, in my view, problems of chilling effect. So then, in the research, I explored a number of potential way forward, how to address not only the procedural deficiencies, but all the problems that I've mentioned before, and so that I identified in my research. So I looked into several options that have been particularly put forward by the doctrine. What about just terminating those agreements, and then we get rid of all our problems? What if we just remove the investor-state dispute settlement chapter in this agreement? Do we then still have a problem? What about just removing IP from these agreements? So we protect investment, but we don't mention IP, and so then we also get rid of the problem. These were not the options that I then further investigated. I rather decided to look at a more proactive approach, and so I assessed the increase in the number of safeguards in these agreements to address all the problems that we've seen before. I made a number of suggestions to make procedural improvements, and particularly interesting, I looked at the investment court system and the proposed multilateral investment court to see whether these could address all the problems we have, or if there are still things to do. So these conclusions allowed me to make a number of policy recommendations, so I would like to mention here 2. First of all, one recommendation would be that in future agreements, or when we revise existing agreement, we include much stronger standards, safeguards for the right to regulate in the agreement itself, and not just in the preamble. Let's add it as a full-fledged right. And why not? I explored also the possibility to include obligations on investors, not just rights. Second, more specifically for IP, suggest to include specific and stronger exceptions and limitations for IP in the agreement itself, once again, not just in the preamble or annexes, and include a full exclusion for compulsory license and the measures related to the existence and validity of IP rights. These recommendations will be relevant, especially because the EU, as I said before, is increasingly negotiating EU agreements, now currently negotiating with India, Indonesia, and Australia, so these recommendations could be useful in this regard. With this, I thank you very much for your attention. This concludes my presentation, and dear Prorector, I give back the word to you.
Thank you so much for your presentation. The opposition will be opened by Professor Christopher Heath. Professor Heath is Professor of Intellectual Property, Foundations and Institutions at our university and he's also the chair of the assessment committee.
Thank you very much. Dear candidate, you can be commended for your excellent, clearly written, and in many ways thorough thesis. And it was a pleasure reading it, I have to say, and this is not the case for all PhD theses. It was a pleasure to read it, and I think your analytical skills in this extremely difficult field are remarkable. Now, the thesis has about 400 pages, and for about 400 pages, you have, in my view, avoided an answer to the question why the European Commission, in its approach to trade agreements, still insists on the insertion of ISDS clauses. It is the elephant in the room. But since you have avoided that question for 400 pages, I will simply leave the elephant there and ask a different question. The relationship between the European Commission, member states, non-member states, and the courts in this field is a very complex one. And I think the Achmea decision that limited ISDS clauses in regard of agreements between member states has come as a surprise to many, I think also the Commission. We still do not know, in my view, what the implications of Achmea are for mixed agreements, that is, agreements between member states and non-member states. And what I find a bit surprising, that also among sort of what has been published from the side of the Commission, there's very little discussion about this. So when you say the Commission wants to go forward with a revised ISDS system with third countries, would this not entail the danger that the European Court of Justice, in its infinite wisdom, at a certain point says, well, but even these tribunals are not competent to deal with EU law, cannot refer questions to this court, and therefore, thank you very much, but all these ways of dispute settlement are equally invalid. Now, has there been any discussion in this regard?
Highly esteemed opponent, thank you for your question. I think, yeah, so as you mentioned, there is a big difference to be made between, so I call it intra-EU BITs, extra-EU BITs. So for intra-EU BITs, it's clear we don't have, we don't want ISDS anymore, so the way forward is to terminate those agreements. And as we know, and as I mentioned in practice, it is taking some time. Huh? And you can see how sometimes even member states themselves seem to be reluctant in just terminating those, which can be also surprising. And as you mentioned, the European Commission's action, the European Commission has actually issued a number of reasoned opinion to accelerate a bit this process. But so that is, at least on one side, we have a clear path. Then for extra-EU BITs, and you mentioned the difficulty maybe of EU law and interpreting EU law. So if you take an investment agreement between a member state, okay, and another country, say France, Chile, I don't really see that EU law should, in an arbitration opposing an investor from one country and the other country, EU law should play such a big role, at least not, it could be mentioned as a matter of fact, but I don't see really which power or what would be the legal basis for an investment tribunal to import EU law and start interpreting EU law. Especially because these agreements can sometimes refer to, they have very strict boundaries, no? So they have to interpret only what is in the investment agreement. Then the investment agreement can mention customary international law or the law applicable between the parties. EU law in a case like this would also not apply between the parties, would only apply to one. And so I see it perhaps difficult that an investment tribunal would really go in depth into interpreting EU law standards. Now, also, I then mentioned the new EU agreements, that are being negotiated, and the improvements that they try to make, especially with the investment court system. There is clear language on what is the law applicable. Now, I don't remember by heart, but there is a strict framework that should apply also in these cases. So I see a limited risk that the Court of Justice would maybe one day come and say, we get rid of ISDS all in all. That would have to come from the EU itself or other contracting parties.
Take the case of Eli Lilly, but based on European patent law as interpreted by the Unified Patent Court. Would that not be a case where a tribunal will interpret necessarily EU law?
So you say a case like Eli Lilly, but where one of the parties is one member state and the other one is
Eli Lilly in Europe, where an interpretation of patent law has been made by the Unified Patent Court.
And is then challenged by the investor. Yeah, I mean, that makes me think of, actually the analogy with Eli Lilly is good, because also there it's a problem, that was also one of my findings. Now in all those cases, the problem is really, the domestic courts decided this, I disagree. So I go to ISDS and I'll challenge it again. Let's see if then they give me, if then I'm right. But what I found is that normally the investment tribunal does not reinterpret what the court has said. So they really rather look at misconduct. There was language used like egregious or shocking conduct by the courts. Of course, you have to rely to some extent to expert submissions now to make sure that, for instance, in Eli Lilly, they had to make sure that the change in the interpretation of the court was not totally nonsense or was not really towards that specific investor, to make sure there was no discrimination. But in my view, it's just my view, I don't think an investment tribunal will suddenly go, especially an investment tribunal not expert in the field of IP law. They wouldn't go and now say, look, let me take the law and reinterpret it as the court should have interpreted in the first place. But they could look at the conduct of the court as such, based on denial of justice as a matter of fact. So in my view, the risk is limited. But
Are you satisfied with the answer?
Thank you very much.
Thank you very much. In that case, the opposition will be continued by Professor Martin Zemsleben. Professor Zemsleben is Professor of Intellectual Property Law at the University of Amsterdam, and he's also a member of the Assessment Committee. And I would like to welcome Professor Zemsleben very much to Maastricht University today. Very good to have you here with us. You are joining us online, and I'm very happy to give you the floor.
Thank you so much. It's a pleasure to be here. Dear candidates, here's the book. I have read it with utmost interest, and I can only congratulate you on this enormous achievement. So whatever is said today, in any case, this is a milestone in the whole discussion about the relationship between investment agreements in the EU and intellectual property. And so we as committee members only do our very best to still find some unresolved issues that might be worth discussing with you. So let me give it a try. In your thesis, you explore the delicate relationship between legitimate investor expectations, so expectations with regard to the stability of the regulatory investment climate in a given state, and then, of course, that state's right to regulate, freedom to change the legal rules that existed at the beginning of the investment period. So more concretely, on page 284, you make very clear that a fine line is to be walked there. You state, states should benefit from a certain freedom when deciding which measures they deem appropriate to pursue a public policy objective, and the threshold should be high for investors to prove that such measures is totally inappropriate to pursue the objective, discriminatory, or adopted in bad faith. Well, I mean, who could disagree with this statement? Of course, the balancing process must follow general open-ended guidelines. You also referred to the principle of proportionality as a guiding principle that can be applied in these contexts. Nonetheless, I would like to try and challenge you a bit on that point, because I'm wondering if, at least in the specific case of intellectual property, we can make this more concrete. Because in intellectual property law, we have, of course, the transnational legal framework, a couple of international treaties, and so on. So why can't we say, as an absolute minimum, that at the very least, states where investments are made are free to regulate within the international intellectual property framework? So what about stating that flexibilities in the international framework for protection always take precedence and always remain available as options for states? So more concretely, my question is, would you agree that at the very least, regulatory measures that do not go beyond flexibilities in the international framework for intellectual property protection, and that would include limitations and exceptions, provisions on justified encumbrances, also compulsory licensing, that at least this are key internationally should always be deemed proportionate, non-discriminatory, foreseeable, and thus acceptable, no matter what the investment agreement says? And then, of course, please do not just answer yes or no, but also give a couple of reasons why you would agree or disagree with this approach.
Highly esteemed opponent, thank you for your question. I would simply answer yes. No, just kidding. No, I would answer, well, yes, first of all. I think this is not only a good idea, I think this is also something that has been followed by the investment tribunals to some extent when looking at IP cases. So, for instance, had we had a case, Philip Morris against Uruguay, where suddenly the investment tribunal had decided to go for a right to use a trademark. So say they had decided, look, actually, well, there is a right to use a trademark, so we give right to the investor. Even in that case, of course, again, they had to rely on expert opinions, etc. But I think there is a clear tendency. Maybe I'm being too idealistic about the work on investment tribunal, but I think there is a tendency to respect the broader international legal framework, especially IP treaties from the side of the investment court. Of course, if you take the investor, they will always try to argue otherwise. So they will not try to respect this international IP framework. They will not try to respect the exceptions and limitations. They will always try to find a way to argue that it was, as you said, discrimination, for instance, that all the measures taken were just made to, attack that specific investor or that specific investment. And so we should not, and I think sometimes we give too much weight, too much weight. We look a lot at the arguments of investors, where you can find a lot of these shocking reasonings for us as IP experts, where investors try to find ways to circumvent IP rules. But for investment tribunals, and I would also dare to say, and I will only speak about the case studies I used, of course, older investment agreements probably were not always drafted like this, but for new investment agreements, there also is clear rules about how you're supposed to apply, which law you can apply to the specific case. So you have to apply, similar to what I was saying before, no? You have to apply any law that is, or you can take into account any law applicable between the party, customary international law. And I think in the sense that would be a way to import, as you said, international IP standards, for instance, as covered in the TRIPS agreement. So all this to say, yes, I agree with you, and I think not only we should do this, and not only investment tribunals should do this, but I think they are empowered and they have to do this, especially based on the language of new investment agreements.
Well, if I may follow up just perhaps with a small further complicating factor. So if we agree that the international framework as such is a good basis, which international treaties would play a role there? I mean, we have a broad spectrum. Would you include also the Lisbon Agreement on the protection of geographical indications, even though it has very limited membership? Or would you take the TRIPS agreement as a starting point?
There, of course, here you point to a limitation. I would say the only ones that an investment tribunal can apply is a treaty that applies to the two parties. So take France against Chile, you would have to look at an agreement that, that both states are signatory to this agreement. Of course, if you take, I don't know, North Korea, probably they're not, I mean, maybe it's a bad example, but I don't even know if they're members of these agreements, but maybe probably they don't even have trade agreements with countries. But okay, let's say in theory they have and they're not signatory or they're not party to one of these agreements, then unfortunately, yes, that would then be a limitation. And then probably an investment could argue, whatever, a right to use a trademark. That would be indeed a limitation, yeah.
Are you satisfied with the answer?
Yes, thank you.
Thank you so much. Now the opposition will be continued by Professor Anke Moerland. Professor Moerland is Associate Professor of Intellectual Property Law at our university, and she's also a member of the Assessment Committee.
Thank you very much, Prorector. Dear candidate, dear Clara, I would like to wholeheartedly congratulate you with this amazing work. I think you are one of the few scholars that masters these two difficult areas of IP law and investment law, and the book really offers a deep comparative analysis of the different cases, but also the agreements that have already been concluded. So these provisions and your analysis really, I think, show the concerns, the interface between those areas very well, and I think that's a good work that you have put into this in terms of research and writing. So this was very, very nice to read. I do have a question, and that deals particularly with your balance that you've tried to achieve between investors' interests and on the other side, public interests. And it's a bit of a methodological question, I think. So I have looked at your research question, and you have shown it to us already. It says, can a balanced investment protection system, including dispute settlement system, be conceptualized in EU agreements for the protection of IP assets? So this question entails a normative dimension of the work, which is explained to lie in the balancing of ethical concerns and public interest on the one hand, and on the other, investors' interest. However, to eventually make an assessment of that balance, a clear operationalization of these ethical concerns and public interest is needed, and on the other side of the interest of the investors. For example, on page 108, you explain it is the safeguards in the investment agreements that can guarantee the public interest as well as the social function of intellectual property. But a clear conceptualization of the potential safeguards and also the threshold they need to meet to ensure the social function is currently not explained to my mind. I therefore would like to invite you to do so now. I'm in search of a normative benchmark that you have used to actually decide whether or not a certain option also that you have discussed in the final part of your thesis, page 301, as to whether these options actually offer an adequate balance, or where they fall short or not, or one is the second best and the first best option. I look forward to your answer.
Esteemed opponent, thank you for your question. I think indeed methodology is actually key to make sure that whatever you propose has some academic relevance, and has some weight. And for sure, there are a number of methodological aspects in the thesis that could have been improved. For this specific aspect, and for your specific question, I actually wish there would be a threshold, as in, something almost mathematical, where we could say, right, now we reach the stage where we have the perfect balance, or where the balance doesn't tip more in favor of investors or in favor of states. I think, unfortunately, in my view, maybe there is one, but I think it is more subtle than this. It is a bit more subjective, perhaps. And one of the main reasons is that these agreements, even though you can have perfect language, first of all, I don't think that even exists, but you can have close to perfect language in the treaty, but then the treaty is handed over to an investment tribunal who will interpret the treaty. And then here again, there is some margin, not even in this interpretation. So unfortunately for that, I think I cannot, and I've not presented in my work a specific threshold that, or specific, maybe I could have included more criteria, no? So, okay, here is criteria A, B, C, D. Let's assess each of the options and see if this complies. I mean, my way was rather to look at, so what I did more in terms of methodology, and when I took my 3 case studies, I was comparing the language of these agreements with some examples of all the investment agreements, not all of them, of course, trying to look at what makes these agreements new, what is the new wording, where do we go further for IP-related measures, no? And when I identified some of those, some of this language, I would assume that these are, minimum threshold that we have to have in all agreements to have some sort of balance. And what I did then in the research further on was to say, maybe we can even go further, because perhaps in my view, some of those, I mentioned sometimes we refer at things in the preamble or in annexes. We make reference to other agreements to make sure that a measure is compatible. For instance, we say with TRIPS, even in some agreements you have this reference. So I went further to say, we can even strengthen the safeguards to achieve the balance, but you're right in saying that I did not offer, say, for instance, criteria A, B, C, D to assess whether each of the criteria, each of the options reach a certain threshold. So then in conclusion, I would say the more the better, the more safeguards we have, the better. I don't think the balance will ever tip in favor of states in these agreements, because at the end of the day, they're investment protection agreements. They're not state protection agreements. But we can go further and making the language better. And as I said before, the EU still has a lot of work to do, probably can take on some recommendations, see what can be negotiated with other member states to include always more of these safeguards. The day we reach the threshold, well, will be the day we have an award, or a lot of award that, academia, for instance, assesses and says, well, okay, here we have a good balance based on this agreement with this sort of language, and I think that will be the day that we can conclude that a specific treaty reached the threshold.
If I may, a short follow-up. So would you say TRIPS compliance would be one such a threshold that you could or have used or have assessed, in a sense that when the flexibilities that we know from TRIPS are also visible, or to a certain extent, is that something that you think is feasible and desirable?
Yeah, actually, this reference is already made in a number of agreements. It is not a reference I like particularly, because I think it invites investor tribunal, and we had this question before, it invites investment tribunals to assess the compatibility of a measure with the TRIPS agreement, which, sometimes I think a bit more ambitious would be just to say, you never question the existence or validity of IP rights. You don't question compulsory licenses. If it's there, especially if a domestic court decided this is valid, this is okay. As an investment tribunal, you don't question this again. Assume it's valid, full stop. For me, that would be the ideal. I don't think well, perhaps, no? It could be, we could try to put it like this in investment agreements and see if it works. But so I think that would be ideal to even not mention TRIPS, not to invite the tribunal to interpret it.
Are you satisfied with the answer?
Yes, thank you.
Thank you so much. Now the opposition will be continued by Professor Pratius Nat Opreti, who is Senior Lecturer in Intellectual Property Law at Queen's University, Belfast, and who is also a member of the Assessment Committee. And Professor Opreti is joining us also online for this academic ceremony. And I would like to welcome him very much to Maastricht University today. You have the floor.
Dear Ms. Candidate, Dear Ms. Candidate, congratulations on finishing your PhD and presenting it before us. It has been a joyful read. So my question is focused on chapter 2 of part B of your dissertation. So in chapter 2 of your dissertation, it demonstrates very good understanding of different aspects of EU investment court system in a broader sense of the broader scheme of the debate, such as anti-counterfeiting trade agreement and the transatlantic trade and investment partnership, TTIP negotiation. The European Union faced several criticism from non-state actors for lack of transparency. And there's also a common view of how these agreements would diminish regulatory control. So in this context, some scholars view that the European Union investment court system is a way to garner legitimacy in the process, terming the EU investment court project as old wine in new bottles. I personally not sure whether investor state or EU investment court system will bring predictability and stability because there's a lack of harmonization of international investment law principles. So to be more specific, my question is, do you think that the EU investment court system would serve as a starting point to address this legitimacy crisis of investor-state dispute settlement? If so, in what way?
Esteemed opponent, thank you for your question. And indeed, I agree with you that the investment court system is a starting point, is not an ending point. And I think even EU policymakers, they had that in mind when in the agreements they already include a reference to the multilateral investment court. That is a project, in my view, on the long term, but investment court system and EU agreements should be replaced by the multilateral investment court should it ever see the light of the day, no? Should it ever be created. So in that sense, yes, first of all, I agree with you that investment court system is a starting point, and it does not solve, unfortunately, all the problems that we know and that I've identified in my thesis. One of the inherent issues with the investment court system is, as you said, it's bilateral by nature, and the court or the arbitral court there would be called to interpret a bilateral agreement based on the very specific wording of that agreement. And it is true that when I was doing the case studies and really comparing the different provisions in the three agreements, even there I found quite important differences in the wording of each agreement, some standards that were included, some not, some deviations, because we were talking about threshold before, some had very high thresholds, some lower, and then you could say, hey, it's all the EU negotiating, and even there you don't have one same language everywhere, which means the day the investment court system interprets one of those, the conclusions that they will formulate, they can normally only be applied to any disputes arising again under that specific treaty. So that is a major limitation of the investment court system. But it does have a number of, it does improve the system in a number of ways. It limits forward shopping, for instance. It allows third-party participation. The fact that you appoint judges rather than having this ad hoc tribunals, they're appointed for a number of years. Even there you have a difference between the treaties. In certain agreements you have appointment for 5 years and another one is 8 years. And so even there you could say, hey, you could have come up with one harmonized, but you negotiate with another country, so they also have their say. But there are good rules in terms of transparency, which is a major issue, and improve ethics. So in this way, let me be optimistic. Let's say that it's much better than what we have in other agreements, but we're not quite there yet. I think the multilateral investment court can achieve much more in theory. In practice, for me, it will take years.
Thank you.
Does that give rise to any follow-up questions or comments from your side, Professor Opreti?
Thank you.
Thank you so much. Then I am very happy to allow Professor Moerland to raise a second question.
Yeah, it's my pleasure to actually follow up with another topic that I think is at the core also of your thesis, which is the dispute settlement system and the ability of also going forum shopping in terms of by the investor. And in that respect, I was intrigued by the forum shopping provision in the CETA agreement, which you characterized as a no U-turn clause on page 195. According to that clause, an investor, in order to initiate arbitration proceedings, will have to withdraw or discontinue any existing proceedings before domestic or international courts or tribunals with respect to a measure alleged to constitute a breach referred to in the investor's claim. The investor also waives his right to bring such a claim in the future. This language, to my mind, is quite broader than other language on forum shopping I know, which requires that not the same claim can be brought. So effectively, what the CETA and other similar provisions in the EU-Vietnam FTA and the EU-Singapore FTA cover are all potential claims regarding one and the same measure. So, for example, claiming a violation of the FET standard under investment treaties and a violation of an IP provision under domestic law for the same measure. Is my interpretation of this broader focus correct? And do you think that this effectively avoids the undesirable forum shopping that I think we are concerned about? Thank you very much.
Esteemed opponent, thank you for your question. I have here the actual provision of the CETA again, so because I didn't remember it by heart, of course, I'm looking at it now. And it is true here that the wording you use is so important, no? Will have such a big, it can make a difference between, you know, you can have, so you refer to the same measure, so it can be you have to withdraw considering a measure, considering a claim. I'm trying to see again what the language was used. So when you refer to a specific measure, so for instance, take the decision of a court, well then, you know, if we consider that to be a measure, we can consider a decision of the court to be a measure, then indeed the impact is quite big. For instance, if in the case like in Eli Lilly, no, if the court decided something, and you're in the investor and you're in this proceeding, then, you know, if the proceeding is already concluded, the Supreme Court decided something, and then you want to bring, okay, it doesn't work here, but say under the CETA or something with the same language as the CETA, can you bring that? Can you challenge the measure or the? Okay, no, that wouldn't be. Sorry, now I'm a bit confused. No, that wouldn't be a good example, because then it's this actual measure that, you know, is being disputed. But so let's say more generally on forum shopping. Having a language like this is already a high safeguard in my view, because, you know, it should in practice ensure that you don't come up at the end of the year, for instance, with two. I think that one of the aim also is to avoid that you get compensation twice, for instance, for the same thing, or 3 times maybe, because you can go to different, or if you didn't get it in one forum, then you can go somewhere else and there get actual money for that measure. So it should prevent this. It should also, I mean, it's also a good safeguard because it should allow, to some extent, for some coherence between the decisions, because the wording also says, you know, that in the CETA, for instance, you have to take, if there are 2 proceedings in parallel, first of all, the investment tribunal will stay its proceeding and then take into account the outcome of the other proceeding and the decision it will make. So, you know, should an investment tribunal then decide it's actually about the same measure, and I think that is maybe the tricky point. That is maybe where the tribunal could say, you know, we're not talking about the same measure here. So then.
Can I just clarify? So the measure, in my perspective, would be that someone is not anymore allowed to use the trademark, as you also referred to before. And that you can bring a claim to say, under trademark law in this country, I should be entitled to use my trademark. And you can also bring the same, this is the measure, that you were not given the right to use your trademark. And on the other hand, you could, under investment law treaty, claim this is a breach of the FET standard, right? The remedies that are available to you are different in both situations. So there is, I think, a legitimate question of, is that a legitimate pursuance of different fora that can achieve different outcomes. So the fact that here one says the same measure cannot be claimed means that one could not bring these two different claims with two different outcomes, but on the same measure, which was, to my mind, to deny access to the trademark in this respect. That would be the example.
Yeah, thank you. That's very clear. Yeah, indeed, in this case, it would qualify as the same measure. What I think in practice would happen is that the investor would would argue something a bit different, would not argue, for instance, hey, you deny me my use to the trademark. They could try that, but then they could try and find the angle of it diminished, they lost a lot of money, it diminished their investment, the value of their investment, and there maybe they could find a way to say it's a different measure. Or the measure could be the domestic court. For instance, there was the case like this, two higher court came up to different, they came up with different judgments, and this is the measure that they challenge. And there I think an investment tribunal would conclude that these are different measures because the underlying measure is the same, but the actually challenged measure is something else. Is the decision of the court, is the decision of the state to whatever, change its law. And so maybe here, there would be also a fine line, between the two.
Now I'm very happy to allow Professor Opreti to raise a question in the second round. Professor Opreti.
So thank you. Dear candidate, in your thesis, you have spent considerable time in explaining Eli Lilly versus Government of Canada, where investors have claimed judicial expropriation based on Canadian Supreme Court decision resulting in change in law arguments. So given the nature of intellectual property law practice at the domestic level, judicial activism has really helped in shaping the national IP system, not only in Europe, even in developing countries, but in context of EU, just to give an example of Court of Justice of European Union, has provided logical interpretation of EU IP laws, which holds both normative and economic significance. Therefore, my question is whether an arbitral tribunal has power to interpret and apply domestic law or divert from legal interpretation by domestic court. So would you like to elaborate on this in the context of EU-Canada CETA compatibility with EU legal order, with emphasis on Court of Justice of European Union opinion on compatibility of EU-Canada CETA in relation to EU legal order?
Esteemed opponent, thank you for your question. The decision of a domestic court could be taken as a matter. A tribunal could consider it as a matter of fact in the case, but indeed, I think because the tribunal interprets the specific wording and provisions of an international investment agreement, you could argue that they could come up with a different solution or a different finding than a domestic court, also just because of the fact that they're not interpreting the same law, right? So domestic courts would rely on, some domestic law, some standards protecting the investment in a way or another. But indeed, and unfortunately, I see it very possible and plausible that an investment tribunal could come up with an award that seems in theory contradictory with the domestic court's judgment, but then you could explain it by the fact that they don't have the same law to interpret in front of them. So this could be one of the reasons that could lead to contradictory, in apparent contradictory judgments, but then again, because you don't interpret the same law, then you can come up with different solutions, yes.
So I just want to follow up on that. I think in Court of Justice of European Union opinion of 2019, in relation to EU legal order and EU-Canada CETA, so I think the Court of Justice had made a clear point that there's a difference between examination and interpretation of the law. So investment tribunal could examine the dispute by looking at the domestic law, but they don't have a power to interpret the law. Even if they are forceful to interpret, because while examining a domestic law, sometimes interpretation can happen. So in that case, whether domestic court is required to follow arbitral tribunal interpretation, where if that is the case, then it goes beyond it goes against the EU legal order. So would you like to elaborate on that point to make a distinction between examination and interpretation?
Yes, and I see your point. This is a very valid point. Then, in this case, the investment tribunal, as you said, there is a difference between taking into account something as a matter of fact or interpreting again the domestic law. I would agree that, in this specific case, then an investment tribunal would have to follow what a domestic court has decided and take this as a matter of fact to further interpret the investment agreements or the investment treaty standards. But they could not reinterpret domestic law, because anyways, domestic law normally should also not be part of their, say, mandate, or should not be part of the corpus of rules that they are empowered to interpret. You can interpret law that's applicable between two parties, for instance. Well, then domestic law normally would not apply to another state. So there indeed, should, because it can happen, should an investment tribunal decide that they have the expertise to reinterpret domestic law, it would be, there you would have a major issue. I wonder, perhaps it has happened already. Would that justify then an annulment proceeding? Could then this be challenged, if the domestic law allows it to challenge the award, actually, to say, this went beyond the powers that this tribunal had? Then, yes. But indeed, as you say, there is a difference between taking an interpretation as a matter of fact and reinterpreting the domestic law, which I don't think would be within the powers of the investment tribunal.
Thank you.
Thank you so much. Now, in his very first question during this opposition, Professor Heath raised an important question, which was about the so-called elephant in the room. And I was just wondering whether the elephant in the room has been sufficiently addressed during this opposition. Professor Heath.
It has not, because it's not supposed to be addressed. It's supposed to be there, like sort of a porcelain elephant. So if you allow me one further question to move around the elephant a bit. In some of the criticism that is voiced against ISDS concerns the one-sidedness of the procedure. In other words, an investor can sue a state, basically risk-free, not risking any countersuit. And there are a number of occasions where a state would very well have been in a position to raise a countersuit. For example, expropriations normally, or in many cases, are not done by rogue governments because they have nothing better to do, but, for example, because the investor disregards environmental protection, labor protection, and so on. And the countersuit would then be, well, sorry, we just do this to protect this and this and this, and you've ruined so much, so you owe us rather than we owe you. Now, this, in my view, corresponds to an equality of arms. But I have not seen in your book that this question was addressed even in regard of an allegedly much better, much improved investor-state court. A court may alleviate certain issues such as the independence of justice and the transparency of proceedings, but is not the lopsidedness of this ISDS, one of the main reasons why, in my view, it should be terminated. In other words, put the elephant out of the room.
Highly esteemed opponent, thank you for your question. I will answer it from the end and go back to the start. The investment court system is, I don't know, unfortunately, it's just intrinsic to what it is. It's about procedure. It is unfortunately not about substance. And so, indeed, what you raised at the beginning, which is extremely important, is a point of substance. So if we have to address this issue of also part of the balancing, in the end of the day, it's also a balancing exercise. This would have to be addressed, in my view, in the investment agreements as such. Unfortunately, not something we can cover when designing the investment court system. And so, in the agreement as such, there are indeed a number of options probably to increase, what you mentioned. There's the possibility to bring what we call counterclaims, counterclaim from the state against the investor. You can also include alongside the rights of investors obligations on investor. That is one of my proposals. Now this is a bit outside of the box because I don't see it yet, but it would be one option.
You may briefly conclude your reply.
Thank you. So in conclusion, in future agreements, this is something we can further improve probably, even stronger language to give some power to states to pursue certain measures. And then my concluding word would be, at the end of the day, an investment agreement is something concluded between two states. It's not something concluded between the investor and the state. So I mean, if states decide that they want to allow this at the end of the day, then it will be very much on them to find the right balance. And thank you very much.
Clara Ducimetière, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company, both here and online, await the results of our deliberations and our return here in this room.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Southside, 7 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. All your time, 'cause I'll go the extra mile. Long road to the south side, 7 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. The mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. It's a better future that we go for. Even though these nights seem long, I know that I am never on my own. 10 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and that. Long road to the south side, 10 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and that. Years can't fly by now, don't waste all your time. 'Cause I'll go the extra mile.
c'est bon, oui, ils reviennent parce que là, ils nous voient. Ah.
Clara Ducimetière. The degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Kamperman-Sanders is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Please all rise.
Do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible?
Yes, I promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Clara Ducimetière, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university.
Please be seated.
Dear Dr. Ducimetière, dear Clara, please allow me to congratulate you on closing the book on your PhD. You have made a remarkable journey throughout your academic career. Your CV shows this as well. It has taken you from law to languages and back. It has taken you from France to Colombia and back. Then, and I have this in good authority, you became a reluctant academic researcher. You needed persuasion and was not sure whether you wished to pursue a PhD at all. Yet you applied for a position as early stage researcher in the IPIN Innovation Society, Marie Skłodowska-Curie Horizon 2020 European Joint Doctorate Program. That started in 2018. This on a project initially conceived by Professor Xavier Seuber, here now present online, who was then working at the University of Strasbourg. In true IPIN Innovation Society spirit, Queen Mary's Guido Westkamp, also present here online, was to provide joint supervision. And from the Maastricht side, we provided coordination of the project, sort of Anke as well, the training on methodology, and where needed, some contents. You very quickly became an active participant in the project's networking activities. And I fondly remember the time spent initially in Macau and Hong Kong, where all the ESRs received their first exposure to the demands of rigorous thinking at the key events that Christopher Heath and I have been organizing with the Institute of European Studies of Macau there since the year 2000. In fact, one of the seminars and the resulting 2019 publication in the IEEM's IP series on IP and international dispute settlement sort of covered the very topic of your PhD thesis, but in a very embryonic stage still. And so all looked well, and you made good progress, until you decided to move to a position at the European Commission, early 2020. Your recruitment by the Commission was incompatible with the Horizon 2020 rules, and you were forced to leave the IP and Innovation Society project. So a reluctant academic became a Commission staffer, and the chances of finishing the PhD seemed to be diminishing, if not impossible. Without a connection to either one of the former institutions, you became an academic refugee. And I remember asking you then whether you would still like to finish the PhD by Maastricht University effectively granting you asylum, and me taking on some of the supervisory duties that still remained. You keenly agreed, in true IPIN spirit. As a bonus, we were able to keep Guido and Xavier on board. And that you stand here today is testament to your determination to see the project through to the end, even if you may never work in academia again. And that may be a pity, but the Commission should be very happy to have you, as the clarity of your reasoning, argumentation, and writing is truly exceptional. I mean, that has been demonstrated here today as well. We have witnessed all of this during this PhD defense here. A reluctant academic, an academic refugee, and an asylum seeker, and now at last here at Maastricht University, a doctor as well. And in true IPIN spirit, we can still celebrate, regrettably with the colleagues online only, but let us celebrate. Congratulations. And now perhaps I can ask the technical people to give the word to Professor Guido Westkamp and to Professor Xavier Seuber as well.
And I think
Thank you, Anton.
Yeah.
Okay, thank you very much. After the words of Professor Anton Kamperman-Sanders, there is not so much I could say about the path that Clara has undergone. And now I should say Dr. Clara Ducimetière. But what I can really say, and I think that it makes a big difference, is her more characteristic feature, what I think that explains her success as well. I know Clara, and I have seen Clara working as a scholar for the last almost 10 years. And if there is something that struck me out since the very beginning, was her determination. And PhD, we all know, is not just an academic endeavor. It's also a personal and I would say life time that you have to invest. And all the people surrounding Clara, families here today, spouses here today as well, know the effort that she has done. Well, she has done that because she has been able, in the concrete moments that this was important, to take bold decisions, to raise her voice sometimes, and I have seen that, and most important, to persevere and advance until the end of this work, and to conclude this brilliant PhD that I'm very happy to congratulate her about. And my final words will be also of gratitude to Professor Anselm Kamperman-Sanders, Professor Guido Westkamp, because it has been a pleasure to work with them, to see how they steered the work of Clara as well. So congratulations, and Clara, I'm very happy to join you in this great day. Thank you.
If I may, if everyone can hear me, dear Clara, dear Dr. Ducimetière, many congratulations. Also from me, I don't have to add too many things in addition to what Ansa and Xavier have already said. I believe you have achieved a lot, not just for yourself, also in comparison with many other PhDs I've seen in the more recent years. I think from the very start, you've really managed to make that topic, that really multi-layered and complex topic, your own. And it's something you can very certainly be immensely proud about. It was a pleasure being your supervisor, also Anselm and Xavier. That really is it. I hope you will be celebrating tonight. I'm sure you will. Many congratulations once again.
Thank you.
Dear Dr. Ducimetière, also on behalf of Maastricht University and its Faculty of Law, many congratulations on the degree you just acquired. I always say it's the highest degree we have available. Many congratulations to you, congratulations to your supervisors, both here and online. And many thanks to the members of the committee, and of course also to your paranims, who I think also played a very important role in assisting you as now our young doctor. And indeed, do celebrate. Many thanks for joining this academic ceremony. That's true both for the audience here in this beautiful room, but also for everyone who joined us online. I still have one practical remark before I'm going to close this ceremony, and that is that we're still going to take the traditional photo of the young doctor together with her paranims, with her supervisors, both here and online, and with all the members of the committee and our beadle. And then there will also be a reception taking place here in this building, and I already would like to ask everyone who is present here in the room to go to that reception, except for everyone who is sitting here on the first row, because you can assist us also in making that photo. And with that, I close this academic ceremony. Thank you.